that way throughout the webinar. Should you experience any technical issues, please use the chat function to let us know or send an email to the mailbox shown on your screen, which is dvrc@opdv.ny.gov. If you lose sound, you can switch your audio and call in to hear. The call-in number is also on your screen. It is 518-549-0500. We will have some time today for questions, but we have a large group. So if there are a lot of questions we don't get to, or if there are questions we don't have immediate answers for, we will prepare a Q&A document following the webinar and send that out later. To ask a question, please use the Q&A function on the right side of your screen and direct your question to me. And again, that's Mary Walsh. We suggest you hold off on posting your questions until later in the webinar. If you have a question early on, it's possible that one of the presenters will address it as the webinar progresses. When asking your questions, please keep in mind that our presenters cannot comment on specific cases or give legal advice, so please keep your questions general. Following the webinar today, you will receive an evaluation. Please do take a moment to fill that out. There was a lot of interest in this topic, so we want to know if the information that we are presenting today is useful and what else you might want to know about the topic. We will be sending the PowerPoint slides, recording of the webinar, and the Q&A document, should there be a need to create that, to everyone who is registered when they are available. And now I'm going to introduce our presenters and turn it over to them to start the webinar. Our presenters for this webinar are Ellen Schell, General Counsel here at the New York State Office for the Prevention of Domestic Violence, Johanna Sullivan, Director of the Office of Public Safety at the New York State Division of Criminal Justice Services, and Lisa Smith, Chief Counsel for Family and Gender Violence, Office of Policy and Planning with the New York State Office for Court Administration. And now, I'm pleased to turn it over to Ellen Schell, who will start off today's program.
First of all, I just want to say thank you to my colleagues on this webinar. We had a lot of interesting and spirited discussions putting this together, and I thank them for allowing me to do some of the more fun parts, I guess. But for now, I just want to talk about some of the whys and wherefores of the presentation. And the why is basically because a lot of our Domestic Violence Regional Council participants wanted this information and said they needed it. And since we have almost 800 people that registered for this event, clearly those DVRC folks knew what they were talking about, that there is interest in this topic. What we'll be covering today is an overview of arrest and bail in New York State under our current laws. But we will not be talking today about the changes to the discovery laws, and we won't be talking about whether bail reform is good or bad. We just want to give you just the facts about what it is and how it is working. And then we're going to talk about what the implications of these changes have been for domestic violence cases. And in essence, we want to talk about how you can work within, around, and through these laws as they exist to create safety for victims, accountability for offenders, and as much justice as is possible for everyone within this framework we have in which to work. Next slide. We did want to start out by saying that we're calling this presentation G-rated for general audiences. We have to acknowledge upfront that this is a really complex and very dense topic. Even as we worked together to create this presentation, we had to have a lot of discussions amongst ourselves about all the complexities of these laws, how they interact with each other. And there are certainly nuances that professionals who work on these issues day in and day out will know. And where those are statutory, we've tried to note them. But it's entirely possible, if you do work with these laws every day, that you might find yourself saying, oh, but what about? And we want to say upfront, we cannot possibly cover every potential situation of what about that might come up. So please understand that in advance, and that we've really tried to make this an accessible, understandable, and basic overview of these issues. I will say that you will be getting the PowerPoint, as Mary said, and there are spaces in the PowerPoint where we have put some statutory references. We are hoping that you'll be able to use these slides and the other materials as resources moving forward. And we haven't always put every little rundown of each subsection or subparagraph in the statute where we've put those references in, but you should be able to find, if you are looking for the specific piece of it, you should be able to find it with the information we've provided. Next slide. So we also just want to introduce some what we're calling critical concepts. It's very, very important to understand that in New York State, bail is not about safety for individuals, for law enforcement, the community, and it's not about whether a defendant is or isn't potentially dangerous. It is only about, and in statute, it is specifically limited to being about whether a person will show up for court when they're required to do so. New York State is in a very small minority where this is true, but it's really crucial to understand this in order to understand the ways the law functions. Another thing that we thought was really important is to understand that both appearance tickets and physical or custodial arrests are arrests under the statutes. Custodial arrests tend to be what we all probably think about when we think of an arrest: the handcuffs, the fingerprints, the judge, maybe some time in jail awaiting the judge. So when we kind of hear, oh, well, someone wasn't arrested, they were just given an appearance ticket and released, what we're really saying is that there wasn't a custodial arrest, but under the law, the person was actually arrested when the appearance ticket was issued. Another thing to keep in mind is that setting of bail does not equal the suspect or the defendant remaining in custody. If a person has the means to post bail when bail is set, whether that is with cash or with some kind of surety, against security against their house or something like that, after they've done so and the court has approved that, they'll be released pending trial. So bail is not sort of the be-all and end-all of this. We do understand that sometimes arranging for bail can take some extra time, and for victims of domestic violence, that time may be helpful, but it is impossible to predict how long that might take. So it's just really something we wanted you to understand at the get-go. Next slide. And the other thing is to understand that the current version of bail reform took effect on January 1st of 2020. And by the state budget, the 2020-2021 budget, that's a lot of 20s, that was passed in April of 2020, there were changes that had been made to this law. That's a really short amount of time for those kinds of things to be changed, but I think it's just important to understand that there was that short period of time. And now I'm going to turn it over to Johanna, who is going to talk to us about arrest and how that works.
I appreciate it. And thank you all for taking the time out of your busy day to join us for this important topic. As we began planning for this presentation, we decided that we thought it would be helpful for all of you to take a case from the very beginning, when the officer first had an interaction with an individual, all through the court process, appearance and stuff. So I'm going to start at the very beginning and talk a little bit about what are the rules and procedures that police must follow from their initial interaction through arrest. And then at the end, I'm going to turn it over to Lisa, and she'll talk about the next step after arrest, what happens next. So the first, an officer's first interaction that an officer you may see is an officer talks about approaching an individual, and they have to decide whether or not they have the legal authority to stop someone and to ask them some questions. And for a lot of different things within our statutes and our case law, there's different standards. And for this option, the officers must decide whether or not they have reasonable suspicion before they can decide whether or not they're allowed to stop and question someone. So the standard for reasonable suspicion, it's on the slide here, but you can see what basically it is whether or not there is knowledge sufficient to induce an ordinary person to believe that there are circumstances that criminal activity is afoot. And the officer in this situation, they can they determine that whether or not they believe criminal activity is at hand. They use their five senses. They determine based upon whether or not some information that was provided to them, whether or not, say in a DWI case, they smell alcohol. These are the types of things that they can decide whether or not they have the ability to stop and question someone. Now, an officer can stop and question someone if they have this reasonable suspicion, but they can only choose to frisk someone if they believe that there's some sort of personal safety at issue. So that's a different standard. If there's some sort of personal safety at issue, then they are allowed to frisk someone. So now I want to go on to arrest authority. When can they determine whether or not they can make an arrest? Now, they've made this initial stop or inquiry based upon information reported to the police, and then they have to determine whether or not they have enough information available to them, whether or not they can make an arrest. And you're often going to see these terms interchanged, reasonable cause and probable cause. Sometimes you'll hear people reference it as reasonable cause. Sometimes you'll hear people reference it as probable cause. And basically, an officer determines that they have the authority to make an arrest when they believe that they receive enough information, either for some of the stop and question that we just talked about, or other information that was provided to them via some sort of other report or data that's provided to them. And they have to decide whether or not that information and evidence is reliable. And if it is enough to convince the officer that, one, an offense was committed, and two, that the individual they are arresting is the one who committed the offense. So as long as they have all of that, then they can decide whether or not they're going to make an arrest. Now, an officer cannot make an arrest for a traffic infraction or a violation if it's not committed in their presence. If a felony or a misdemeanor occurs and is reported to them and they feel that they have reasonable or probable cause, they can make that arrest, whether or not it happens in their presence. But a traffic infraction or a violation arrest, that can only occur if the incident occurs in the presence. So what does that really mean? So for example, if it is reported to an officer that something like a harassment second, which is a violation, something where an individual says that they were slapped or shoved, maybe more likely more of a shove, and they were subject to some sort of physical contact, but it didn't result in an injury. That is most likely, obviously fact patterns, as Ellen said in the beginning, can be complicated, but that's most likely a violation. And if that doesn't happen in front of the officer cannot make an arrest based upon just being reported to them. However, even if an officer cannot make an arrest, an officer in every single family offense must complete a domestic incident report. Whether they make an arrest or not, a DIR must be completed if it's in fact a family offense that they respond to. And then within the DIR, an officer reviews the DIR and must check whether or not they've got to do a number of things when I'm sure many of you are familiar with the DIR and have seen them. They've got to do a number of questioning and filling it out. But two important key pieces on there are the DIR repository and the OP registry. Every officer in the state has access, either themselves or through their department, to both the OP registry and the DIR registry. And so as they complete the DIR and they check the registries, they may determine that now they have probable cause to believe that an arrest occurred. Say they have an OP and the harassment that we just talked about occurred, maybe, and it's a full stay away OP, maybe now they have a criminal contempt charge, okay? So that DIR must be completed regardless of whether an arrest occurs, and an officer must check the DIR repository and the OP registry regardless of whether or not an arrest occurs. Okay, so let's talk a little bit more about mandatory arrest. Now, this is a subject that I think many of you are intimately familiar with. But in this situation, you've got an officer has to, they come to the scene, they reply, they have the reasonable suspicion, they do some stop and question. They now feel like maybe they've gotten to the reasonable or probable cause that we just talked about to believe that an offense was committed and to believe that the individual in front of them is the person that committed it and that it was committed against a family or household member. So if they have probable cause to believe the offense is committed, that the individual committed it, and that it was committed by a family or household member, and it's either a felony or a violation of a stay away order protection, or a violation of a refrain from order protection, and the violation that occurred in that refrain from order protection is an enumerated family offense or a misdemeanor enumerated family offense. For any of those, the officer must make an arrest. Mandatory arrest must apply. So you got probable cause to believe this individual committed it. They're a family offense. It's either a felony, a violation of a stay away OP, a violation of a refrain from, that's an enumerated family offense, or a misdemeanor enumerated. Then the officer must make an arrest. Now there's one exception to that. If the victim in the misdemeanor enumerated family offense asks that for an arrest to not be made, then the officer can choose to not make the arrest. However, the officer cannot ask the victim if they want the offender to be arrested. Okay. Now, the next thing, the officer is now determined, okay, mandatory arrest applies. The next thing the officer has to decide is, what kind of an arrest am I going to make? Am I going to make an arrest where I bring the person into physical custody? Or am I going to make an arrest like Ellen talked about before, where I issue an appearance ticket? So we have to talk a little bit about that because there are some laws that got changed regarding appearance ticket when the new bail reform went into effect. So let's talk a little bit about appearance tickets and when they cannot be issued, and when they cannot be issued, when they must be issued, and when the officer has discretion. So if we can go to the next slide, thank you. So anytime the individual and the crime that's being charged or believed to be committed is, if it's a crime of an A, B, C, or D felony, and certain E felonies, the ones that are on the slide right here, rape 3, criminal sexual act 3rd, escape 3rd, absconding from temporary release, absconding from community treatment, or bail jump. If you have any one of those, the A, B, C, D felony, or these E felonies, then the individual cannot be issued an appearance ticket. They must be brought physically before the court, so brought into physical custody and then brought before the court for arraignment. An appearance ticket cannot be issued. Now, as I said, though, there are other times in which an appearance ticket must be issued. So let's talk a little bit about that and when an officer has discretion. So the laws changed, and I think there's been some confusion out there, but the backbone is basically in most E felonies, misdemeanors, and violations, an officer should be issuing an appearance ticket pursuant to the new statute. However, the officer has discretion, and they can choose to not issue an appearance ticket and instead bring the person into physical custody when there are these certain exceptions. And the exceptions are if there was an enumerated family offense. If an enumerated family offense was the allegation, an officer can say they do not want to issue an appearance ticket, and instead they want to bring the person into physical custody and bring them before the court. Similarly, same thing with the sex crimes or an open warrant. That's for a New York State warrant. Or if they fail to appear in another state within the last 2 years and they fail to appear in a court proceeding, that individual cannot be issued. The officer can choose to not issue an appearance ticket and bring them before. Or if you need to have an OP issued in a non-DV case or get some sort of other DMV restriction where the court needs to take some action, then in those cases, the officer can bring them before the court. Or there's an escape 3rd or a bail jumping, or the case maybe is one that calls for diversion. Or if they believe the individual needs some sort of medical or mental health care, then you can choose to not issue an appearance ticket. And lastly, if they refuse to provide verifiable identity or contact information, the officer can choose to say, I'm not going to issue an appearance ticket. Instead, I'm going to bring you into physical custody and you're going to come before the court, even if, obviously, these are all the E felonies and misdemeanors. As we said before, A, B, C, D, or those other specific E felonies that we talked about just a few minutes ago, those must be brought. Appearance ticket cannot be issued. But for all other E felonies or misdemeanors, when you have these exceptions, the officer can choose to bring them into physical custody and bring them before the court. So now let's talk about that. Even when you have situations where maybe you're just going to issue the appearance ticket, there may be situations where you still can fingerprint them. So let's talk a little bit about fingerprinting. Okay, the law, there are lots of changes in the law, but CPL 14020, it still stands even after some of the reforms. And it says that an officer must fingerprint someone prior to arrest, prior to issuing an appearance ticket when the charge is for felonies, misdemeanors. So if you have a felony or misdemeanor before issuing an appearance ticket, according to 14020, the officers must fingerprint the individual. The other thing that comes about, like we just talked about, is even if it's not one of those, the officer can fingerprint someone for any sort of violations. And they can fingerprint someone if they want to determine who the individual is. So we just talked a little bit about the fact that if they don't know who the individual is, they don't have any identifiable, if they don't have any identifiable information on them, say they don't have or verifiable information, the officer can choose in those cases to fingerprint them and bring them before the court, okay? So the officer, even when it's maybe not one of those situations, but they just don't know who the individual is. Maybe the person's not being forthcoming about their name, or maybe they're bringing identification that the officer believes is a fake identification. In those situations, the officer can choose to fingerprint them and then issue an appearance ticket. So those are some other areas where you might not see an appearance ticket issued on the street. You may see the individual be brought in, fingerprinted, felonies, misdemeanors, and other violations, and then issued the appearance ticket. Some cases they might be released, and some cases that we discussed, they may be brought before the court that same day, okay? And some of the laws that changed regarding appearance ticket is now an officer must inform the arrested individual that they can provide contact information for court notification purposes. So when you're issuing an appearance ticket, obviously the person's told to come back later. Their officer has to get the contact information, whether it's a phone number, email, something like that, so that the individual can in fact be notified about the court proceedings and what's going on with the court proceedings. So that's new after the laws were changed. And if a person, as I just discussed before, is unwilling to provide contact information and unwilling to provide specific information about themselves, then that individual can be brought into physical custody and brought before the court. So I've taken you through when you can be issued an appearance ticket, when you can't be issued an appearance ticket, and when the officer has discretion and probable cause in some of the beginning processes. And now I'm going to turn it over to Lisa to discuss the next steps in the process.
Thank you, Johanna. So now we're moving, as Johanna said, from arrest to arraignment. The important thing to remember is that an appearance ticket is an arrest, but it has a later arraignment date. So the defendant is just being told to come back to court whenever it says on the appearance ticket for the later arraignment. The custodial arrest leads to an immediate arraignment. Now, why is this specifically important in domestic violence cases? I'm sure most of you know that the reason is that if you issue an appearance ticket, you cannot get an immediate temporary order of protection in the criminal court. So if it's a custodial arrest, obviously an immediate temporary order of protection can be requested and issued by the judge if the judge were to so decide. Now remember that if there's an appearance ticket and you are unable to get that immediate temporary order of protection, the victim in the case can still go to the family court and attempt to get an ex parte order of protection. In the CPL in New York, you are allowed to have concurrent family court cases and criminal court cases pending in the area of family offenses. So that is an alternative. And something that is important for everybody to remember also is that if the family court is closed, you can go to the criminal court because the criminal court is empowered to act as a family court and issue ex parte temporary orders of protection when a family court is unavailable. But this is something to keep in mind so that if you are having a conversation with a law enforcement representative and you're talking for some reason about the issuance of an appearance ticket versus the custodial arrest, of course, what you want to discuss primarily is that a temporary order of protection will not be able to be issued by the judge unless you do a custodial arrest. Who is at an arraignment? Who can you expect to see there? There's a judge, the defendant. Depending on the court and the geographic jurisdiction, there may be a prosecutor present. there's a defense attorney, and again, depending on the court and the geographic location, you may have law enforcement present at the arraignment. So what is the purpose of arraignment? At an arraignment, the defendant is made aware of the charges that are now pending. Rights are explained. Again, as I said, a defense attorney is assigned. A temporary order of protection may be requested. There are obviously other things that happen at arraignments, but we're doing this in the context of the general information that people requested through the DVRC meetings. And there's a discussion of a securing order. What are securing orders and how do they work? The CPL 500.10 talks about the definitions of securing orders, and this is where the concept of bail arises. A securing order is an order of a court, meaning from the judge, committing a person accused of a criminal offense, the defendant, to the custody of the sheriff, or fixing bail, or releasing on their own recognizance. So release on own recognizance is ROR, which everybody is familiar with, and that's where the term ROR comes from, some CPL 500.10. An ROR is a securing order that allows a person to remain free under the condition that they will appear in court on the next date as ordered by the judge. It simply means that you are released from custody. You're instructed to return to court. The criminal case is still proceeding. You are just ROR'd. It's not a dismissal. The criminal case is proceeding. It's a custody order. Bail is another type of securing order. It designates a sum of money that, if posted and approved by the court, also allows the person to remain free while the case proceeds. Case still exists, still proceeding. It's just the defendant is out on bail. The concept behind bail is that if you post bail and you fail to appear, the defendant or the person who may have guaranteed the bail is going to lose that money. If you're committed to the custody of the sheriff, that's a different type of securing order and requires a person to stay in the custody while the case proceeds. That's like a remand and more commonly used in homicide cases. Now, bail can be re-argued on later dates. It can be re-argued by the prosecutor. It's the next slide. Oh, sorry. At subsequent court appearances, but that's generally if new information is now known and can be presented to a judge that the original judge who made the original bail decision was unaware. Now, what type of securing order may a court make? The new law created two different categories involving securing orders. One is called qualifying offenses and one is called non-qualifying offenses. Qualifying offenses are eligible for monetary or cash bail. The court can use its discretion to release the defendant charged with a qualifying offense. They can still ROR if it's a qualifying offense. They can ROR with conditions, or they can set monetary bail. But the court is mandated, even in a qualifying offense, to consider and use the least restrictive alternative to assure that there's a return to court by the defendant, the least restrictive alternative. And that is what their decision must be based on. Let's talk about qualifying offenses. So remember, now we're talking about qualifying offense where a judge has the option. It's a may, remember, it's not shall. So the judge is not mandated to use cash bail, but these are the cases in which a judge can consider cash bail. So this is going to be a long list of qualifying offenses just to give you a sense of them. So witness intimidation, witness tampering, sex offenses, certain criminal contempts, certain obstruction of breathing and strangulation. You can see that the italicized offenses were added later after the initial legislation. So here's something that was added. This is a very typical type of domestic violence situation. So everybody should know because this applies frequently. So Any felony or Class A misdemeanor involving harm to an identifiable person or property where the charge arose from conduct occurring while the defendant was ROR'd and was released under conditions for a separate felony or Class A misdemeanor involving harm to an identifiable person is now a qualifying offense. What does this mean? So in simple, plain language, what this actually means is, let's pretend for a second that on November 1st, 2021, a defendant is arrested for assault in the third degree, which is an A misdemeanor. And let's say that the complainant in that case was an intimate partner. And when that case went before the judge at arraignment, the judge issued ROR. Could have been ROR, could have been ROR with conditions. But that was the securing order decision. Pretend that 3 weeks later, on November 21st of 2021, that same defendant is arrested for another Class A misdemeanor, another assault in the third degree. This commonly happens in domestic violence cases. The complainant is again the intimate partner, an identifiable person. Now, on the second arrest, because the defendant was ROR'd on the first arrest and was rearrested while on ROR, the new assault in the third degree can be considered a qualifying offense, and a judge has the option, does not have to, because still least restrictive alternative is still in the decision-making process. But now the judge has the option of setting monetary bail. Additional qualifying offenses, as you would obviously expect, are violent felony offenses, Class A felonies with some exceptions, sex trafficking, conspiracy, money laundering, sexual performance of a child, and additionally, any crime alleged to have caused the death of another person, failure to register as a sex offender, bail jumping, any felony offense committed while serving a sentence of probation or release to post-release supervision. These are all offenses in where a judge does have the option of cash bail. And to continue, and obviously you can read this in the PowerPoint later, additional felonies, aggravated vehicular assault, assault 3 is a hate crime, aggravated assault, grand larceny, etc. So these are all qualifying offenses, as I said, where a judge can consider cash bail if it's the least restrictive alternative to ensure that the defendant is going to return to court. Now, what happens in that second category of cases that I mentioned before? Non-qualifying offenses. In a non-qualifying offense, which is everything but the ones you just saw, the court must release a person charged with a non-qualifying offense on recognizance, ROR, unless the record demonstrates that they cannot be reasonably assured to return to court. And then what you can do is add non-monetary conditions to the ROR, but cash bail is prohibited in non-qualifying offenses. So, what are the release conditions in these non-qualifying offenses? ROR, so these are the options before the judge. It's important to look at this list because there's a lot of options. So yes, you can just ROR, but here's a list of other conditions pursuant to the CPL 500.10 that a judge can add if the judge believes that there's a reason to do so to ensure that the defendant returns to court. You can add ROR with pretrial services, travel restrictions, firearms prohibitions, which most of you know are also part of orders of protection, pretrial supervision, and additionally, you can add refrain from associating with certain persons connected with the charge, including specified victims, witnesses. You can add pretrial supervision with agencies that do counseling, treatment, and intimate partner violence intervention programs. These can be added to an ROR securing order. Removal to a hospital under 9.43. You can add, the defendant has to make diligent efforts to maintain employment, ROR plus employment, ROR plus enrollment in school, ROR plus obeying an order of protection. And you can also add conditions set by the court that the court feels addresses the safety of the victim of the family offense, including conditions that may be requested by or on behalf of the victim. And you can also use electronic monitoring in these non-qualifying offenses. So the legislation, although for non-qualifying, says no monetary bail. It doesn't say your only recourse is just an ROR. If a judge feels it's appropriate, you can have ROR with any one or all of these conditions if appropriate. So, risk of flight, meaning that the defendant will not, that the judge feels that it is very likely that the defendant will not return to court on the next court date. New York State is a risk of flight, as Ellen said early on, jurisdiction, which does differ from other states in the federal system. Securing orders are only based on whether the person will show up for court appearances. And judicial decisions pursuant to CPL 510.10 must be on the record or in writing. Now, remember, I just want to add here that there are other tools, though, that exist that do consider, that are not, tools that a judge might use, but that are out there to consider for the safety of victims. And a couple of things to keep in mind is that law enforcement, the Sheriff's Association, does have an inmate release notification system, which all complainants in domestic violence cases can enroll in. And they also have an order of protection notification system. And that program immediately notifies victims or the party on for whom the order was issued, when it's served and if it's expired and continues. So those are a couple of tools that you should always keep in mind are out there for the safety of victims. And many of you have worked with me on this, so you're not going to be surprised to hear me mention this. But remember that on firearm surrender, another thing to consider when you're worrying about the safety of a victim, if that's what you're focusing on at the moment, is that orders of protection do include a firearm surrender directive. And as a lot of you know, the courts have been working very closely with law enforcement, the courts and advocates around the state to issue directives about firearm surrender. So when a judge is sitting in court and they're trying to decide that question I just asked, will the defendant return on the next court date? And what is the least restrictive condition to assure that return? The court, pursuant to the criminal procedure law, has to consider some of the following. But remember that it's all in the context of non-return or risk of flight. So the judge is allowed to consider the defendant's personal situation, resource, and characteristics and history, criminal history or lack thereof, history of appearing in court or failure to appear. Obviously, right, a very clear indication of whether it's likely that the defendant will appear in this particular case before the judge, the weight of the evidence and other factors regarding possibility of conviction, and the possible sentence if convicted. So what are those about? Why does that impact risk of flight? Well, obviously, if it's likely that the defendant is going to be convicted or will have to plead guilty, and the possible sentence is harsher than another sentence, than another possible sentence, the likelihood of flight, risk of flight, is much greater if a defendant is reasonable to think that risk of flight is greater if a person thinks they're going to be convicted and thinks that the possible sentence could in fact be incarceration. So that's why that is included in things that the judge can consider at the arraignment when thinking about whether a defendant will return to court. In a case where you're charged with an enumerated family offense, in a DV case, the judge can also consider any violation of an order of protection issued by any court for the protection of a member or members of the same family or household, whether or not such order of protection is currently in effect, and the person's history of use or possession of a firearm. So judge can also consider that under the CPL. Remember that in cases of family offenses before the court may enter a temporary order of protection in conjunction with the securing order. So there's nothing about bail reform that changes anything about the issuance or the ability of the judge to issue a temporary order of protection, and that includes putting in that order of protection any of the conditions that the judge thinks should be there. That is separate from the analysis that I was talking about before, the analysis about will the defendant return to court. So keep in mind, temporary order of protection analysis is not about defendant returning to court. That is a completely different set of factors that a judge has to consider. And if a defendant willfully failed to obey a court order under the CPL or an order of protection, and it can be proven at a hearing, the judge can revoke the order of recognizance, revoke that, the ROR or bail, or order forfeiture of such bail and commit the defendant to custody. Now, Ellen is going to talk about specifically how everything we just discussed interacts with the issue of domestic violence.
Thank you, Lisa. So I think it's important at the get-go that we understand that for enumerated family offenses, physical arrest or appearance ticket is discretionary with the officer under the CPL. But that the mandatory arrest law still applies, and Johanna talked about that in detail. So I'm not going to talk too much about that, but again, just to remind you that if you have any ability to make this decision, that in a family offense case, it's a good practice to bring the person in front of the judge. So if an order of protection is needed, it can be issued and served on the defendant, often right there in the court. It's just something that we wanted to reiterate, and I think we've done it a couple of times at least. I wanted to talk about electronic monitoring because Lisa mentioned it, but we didn't really talk about too much about it. But electronic monitoring, when this initial legislation was put together, really seems to have been sort of thought of as the remedy to take care of things in domestic violence cases, because most or many enumerated family offenses and other domestic violence, common domestic violence charges were not included as qualifying offenses in the original legislation. So electronic monitoring can be used in any felony and any misdemeanor crime of domestic violence. Now, it's important to understand that the way that is defined in the statute limits it to enumerated family offenses. So there are other misdemeanor crimes that may be committed by a member of the same family or household against an intimate partner or another member of the same family or household, but they must be enumerated family offenses in order to qualify for electronic monitoring. There are some things that are not electronic monitoring eligible because they're not enumerated family offenses. And, you know, particularly, and I'll talk about these in more detail a little later, that's criminal contempt second, endangering the welfare of a child, unlawful imprisonment second, tampering with a witness fourth. And we frequently see these charges in domestic violence cases, but those are not electronic monitoring eligible. And there are a lot of details about electronic monitoring, how long it can be ordered for, and who has to actually do the electronic monitoring, but this is sort of the basics for our purposes. And then again, Lisa talked about some of these, but the new domestic violence qualifying offenses are criminal obstruction of breathing or blood circulation and strangulation second. Strangulation first was previously a qualifying offense because of the level of felony that it is. Unlawful imprisonment first. These things were all added as qualifying offenses when they are related to crimes against a member of the same family or household. So if they are committed by any of the usual suspects that we think about in family offenses, an intimate partner, a spouse, someone that has a family relationship of some way as that is defined. And then I wanted to talk a little bit more about what Lisa mentioned, this new situation where a felony or Class A misdemeanor involving harm to an identifiable person or property occurs while the defendant was ROR'd or released under conditions for a separate felony or Class A misdemeanor involving harm to an identifiable person or property. The prosecutor has to show reasonable cause to believe that the defendant committed both crimes, but I just wanted to give an example from a case or a couple of cases I prosecuted when I was an ADA in Essex County, because this is just so, it really crystallizes what this applies to. So this is a case of a woman who had an ex-husband who we were shall we say, very aware of in the DA's office, quite familiar with the gentleman. And one morning, she looks out her window, and you can imagine she's got a car. She drives to work. That's what she needs to go to work. She looks out her window. She sees the ex-husband standing next to her car with a rock that he picked up from the garden that was next to the driveway, and he's smashing the car window. She calls the police. He's arraigned, ROR'd with a stay-away order of protection, waiting trial. Now, it was a misdemeanor, an A misdemeanor, criminal mischief at that point. So she gets her windshield replaced. And the day after she replaced the windshield, she comes out in the morning and she tries to get in her car to go to work, and her newly replaced windshield is smashed to smithereens. And the same exact rock that he used the day before to break her windshield while she was watching was sitting on the hood of the car amid all the broken glass. So whether or not the underlying crimes are qualifying offenses, this would raise that second arrest to the level of a qualifying offense, where a judge could consider whether to set bail, or could consider in some ways increasing the numbers of conditions that the person needs to be following. So I just always think of this as sort of the quintessential illustration of this particular new way of thinking about whether something's a qualifying offense. I'm going to run through in the next few slides the list of enumerated family offenses. There are a lot of them, and you, as we've said before, you do not need to take notes on this. You're going to get this PowerPoint. But so I'm going to go through these rather quickly, but I just wanted to make sure that you understand that these will all be given to you, so you can use these for resources in the future. Now, what I've done is I've highlighted some of these enumerated family offenses. And, you know, we've all worked with these. I'm sure anybody who's worked for like a minute and a half working with domestic violence victims is familiar with these offenses. And, you know, the disorderly conduct and harassment second are violations. The rest of them are either misdemeanors or felonies. So the sexual crimes were any sex crime that is defined in the penal law, Article 130, was accepted out at the very beginning of bail reform and made, those were all made qualifying offenses. Stalking first is also a qualifying offense. And then all of the stalking charges are enumerated family offenses, all of the levels of criminal mischief. We added recently unlawful dissemination or publication of an intimate image. So we kind of shorthand that sometimes to say revenge porn. So there's a lot of them. And then there's a bunch more, menacing, reckless endangerment. And these again, strangulation first and second, and criminal obstruction of breathing or blood circulation are qualifying offenses, as is assault second, because of the level of felony it is. And I have assault third highlighted in a different color because, as Lisa talked about, it's only a qualifying offense if it's committed as a hate crime. So it's not going to be in most situations that you can sort of conceive of in domestic violence charged as a hate crime. But it is under that one circumstance, a qualifying offense. Then we've got attempted assaults, and you have to really parse out for an attempted assault whether it might or might not be a qualifying offense, because if you're not familiar with attempts are charged at one level lower than the initial crime would be. So if it's a felony assault, an assault second it was an attempted assault second would not be a qualifying offense because it doesn't rise to the right level. But an attempted assault first would in fact be a qualifying offense. So it's just attempt crimes are a little difficult. Leave that to the DAs and the police to figure out because they're tricky. So here's just another way to look at it. This sort of takes these and puts them all into one slide. These are the enumerated family offenses that are qualifying offenses under the statutes. The sex crimes, stalking first, strangulation first and second, and criminal obstruction of breathing or blood circulation, and assault second. Now, one of the things that was kind of interesting early on when the initial legislation was passed is that criminal obstruction of breathing or blood circulation, it's a misdemeanor. In my humble opinion, the a misdemeanor is charged much too frequently when there could be felony charges, but it is charged extremely frequently. And it was not, it was eligible for electronic monitoring, but it was not eligible to be considered for bail. And so in my perspective, this was a good addition to the list of qualifying offenses because it is something that is so dangerous and indicates really a disregard for whether someone lives or dies. So this is something that I think is quite useful to have been added. Now I want to talk about some domestic violence and enumerated family offense charges that are not qualifying offenses. And so these are, disorderly conduct and harassment second. Those are not qualifying offenses because they're violations. They're not even considered crimes under the statutes. Harassment first, aggravated harassment second, stalking second, third, and fourth. All levels of criminal mischief, menacing second and third, reckless endangerment first and second, assault third, again, unless it's charged as a hate crime, aggravated family offense that I'll talk about a little bit later, endangering the welfare of a child, unlawful imprisonment second, tampering with a witness fourth, and coercion second or third. Excuse me. Now, you will see this list contains a lot of crimes that are very regularly charged in family offense matters in domestic violence cases. And I think it's just really critical to understand that if they're enumerated family offenses, they are eligible for electronic monitoring, but they may not be eligible for bail. So I'm going to talk a little bit more about why some of these things fall out the way they do under the way these crimes are categorized. An aggravated family offense, for people that might not be familiar with it, it is an e-felony that where someone commits a misdemeanor in a very long list of specified offenses in the statute. It's quite interesting if you wanted to look up the statute to see the list, very extensive list of specified offenses. When they've been convicted of another one or more of those specified offenses in the previous 5 years. So this is it was a legislative way to try to get to the problem of people being charged kind of over and over and convicted of misdemeanors in domestic violence cases, but not ever getting to the point where they're charged with a felony. Now, all the specified offenses, not all of them are enumerated family offenses, and not all of them are misdemeanors. So you can think of a case, for instance, when someone was convicted, say in 2018, for any specified offense in the list against a member of their same family or household, and then later is arrested, say 2021, they're arrested for some misdemeanor specified offense, like an assault third or a criminal obstruction of breathing or blood circulation. It's important to understand that that second crime doesn't have to have been for a crime against the same person that the first qualifying or specified offense was committed against. It could have been a different person altogether. They could have moved on to a new partner and be committing the second offense against that new partner. But they could be charged with an aggravated family offense based on that second conviction or that second charge, and that raises it to the level of an e-felony. Now, it's not, because it's an e-felony, it's a mandatory appearance ticket, mandatory ROR, whether with or without conditions. Again, that's up to the court in making that determination about what will get them to return to court. And then electronic monitoring is allowed in this situation because it's a felony. But there's no bail or possibility of remand. But keep in mind that it's possible that the underlying charge may be a qualifying offense. So in that sort of description I just went through, if that second charge had been criminal obstruction of breathing or blood circulation, then you have a situation where the court may consider whether to have to set bail because that underlying charge is a qualifying offense, even if the aggravated family offense itself is not. It's just, there's a lot of places where the various definitions sort of play into things that you really have to sit down and parse out, which I started having to do when bail reform first was being talked about, and people were saying, like, what is this going to mean for our cases? What is this going to mean? And I, at the beginning, kind of had to say, not sure. I'm going to have to figure that out. And so there are certainly places we figured out that some things don't necessarily make a lot of logical sense, but you just have to look at each statute and figure out how they all intersect. Criminal contempt second, it's a little weird, but when you, again, work through the statutes, you can figure out why. So electronic monitoring is not allowed in a criminal contempt second case, but it is a qualifying offense. So it's eligible for bail to be set if the court determines that that is necessary in order to assure the defendant's return, but it is not eligible for remand. And so because it's not an enumerated family offense, that's why electronic monitoring isn't available in a criminal contempt case. But again, perhaps there was an underlying enumerated family offense committed that would allow electronic monitoring in that situation. And it's not a felony, so it is not a qualifying. I mean, it's not remand eligible. So it's just, you just kind of have to work through how these things play. endangering the welfare of a child is something I've seen quite often in DV cases. And it's an A misdemeanor. It remains a mandatory appearance ticket, mandatory ROR with or without conditions. There is no possibility of electronic monitoring because it is not an enumerated family offense, and no bail or remand is possible. So that is a case that you're going to see, that's straightforward. It's a misdemeanor. It's not an enumerated family offense. There's a mandatory appearance ticket and a mandatory ROR. So I wanted to just kind of talk a little bit about some of the ways we've thought about to work within these laws that we have. I think, one of the things you really want to think about from the very get-go is, are there qualifying offenses that can be charged rather than non-qualifying offenses? Look at the facts of your case and think about whether there might be another charge that will equally fit the facts, being able to contain all the elements that would be needed for one of those qualifying offenses. Also, to look at whether there's a history of orders of protection and violations of OPs. And you'll remember that Lisa talked about that being one of the factors that in an enumerated family offense case can be considered by a court in determining what kind of securing order to make. And it's logical. So if this offender has a history of not obeying other kinds of court orders, i.e. orders of protection, that should really be considered in determining what kind of conditions or how much bail might need to be set in order to assure their return to court. Because, we know from working with these cases that a lot of DV offenders pretty much thumb their nose at the court and violate OPs quite regularly, and they're not always charged, which I think just kind of convinces the offender that it's not such a big deal. But when you've got an offender like that who you're looking at whether they're likely to return for their court appearance, and you see a list of arrests for violations of previous orders of protection, you have to think that that person might not be paying too much attention to the order you're going to set requiring them to return to court. So I think that is something that courts really need to take a close look at. And as we said, law enforcement and courts all have the ability to look back at that OP registry and see how many OPs there have been and look at potential arrests for violations of those OPs. Again, look into someone's history of the use of firearms. If bail is being considered, that is really the only factor in our bail laws that kind of really is about safety in some way. If someone's got a history of having used firearms or threatened to use firearms, that's something that a court can consider in setting bail in a qualifying offense. I think it's important for practitioners of all stripes to know whether your county has an eligible and reliable electronic monitoring program. All of these laws really took effect in the midst of the COVID pandemic, and they were already a pretty big lift for a lot of counties in how they set up some of the requirements of the electronic monitoring programs and the pretrial supervision agencies. And so I think it's just things have really started to get rolling quite well now, but it's important to know for your own county what those resources might be in cases that you have, so that you can think about asking for electronic monitoring if it's in fact something that's likely to be helpful. Think about whether this is the situation we talked about where with the 2 broken windshields, where the person is on release and commits a similar crime against an identifiable person or property. Because this is, as Lisa said, kind of one of the quintessential things you see in domestic violence cases. Sure, there are some domestic violence offenders who really understand, power and control, and know that the court has power over them while they, have an order of protection or on release, and will not misbehave. But there are a lot of them that really don't seem to care much and will go ahead and commit other offenses against their intimate partner or other family member blithely while they're already on release for other things. So I think this is really a potentially extremely useful thing to keep in mind.
And Ellen, I just wanted to throw in there something that you just said. It's very important. It doesn't have to be the same identifiable person. So that, remember, if you have cases pending, as Ellen was saying, where the complainant is one intimate partner in one case, but a different intimate partner in another, or a different family member, this still applies. It doesn't say same person. It just says identifiable person or property, which is very important in these types of cases.
Thanks, Lisa. Yes, that was a really good clarification. And I will say, like, when you think about what's an identifiable person or property, you kind of just think, like, do you know where that person is likely to go commit a crime? Yeah, it's probably going to be against a member of their family or against the house that the member of their family lives in. So yeah, that was a really good point, Lisa. Also, we want to think about whether the offender's currently on probation or parole in the situations that that Lisa talked about, because in those cases, some crimes charged will allow the court to consider whether to set bail or not. And
Right.
the underlying probation or parole does not have to be for a felony. They could be on misdemeanor probation, but if they commit another offense while they're on probation or parole, that makes it a qualifying offense. Were you going to add something else there, Lisa?
The offense before the judge at that time has to be any felony. Has to be
Okay.
any felony offense while committed while serving, while out on probation or parole.
Thank
Sorry
you.
for the interruption.
No, that's fine. I want to make sure we get this right, so I appreciate that very much. You also might want to think about whether you have facts that support an argument that the person needs pretrial supervision in order to assure their return to court, or maybe even just services. Because if you kind of think this through, if the court directs them to get substance abuse treatment while they're awaiting their trial or something like that, and they don't follow through with those services, that is something the court may want to consider in whether even to, step up what conditions have been ordered, or potentially, depending on the charge, to require to think about putting bail in place. So those kinds of things about what are the conditions that someone should have, or should they be supervised, all of those things can be sort of useful in the big picture of how this case can play out. And then, do the facts fit an enumerated family offense charge so that electronic monitoring may be available? And I think there's lots of ways to think about these cases and to understand that, sometimes there are things that can be done that can weigh the scale toward victim safety, offender accountability, and justice. So in closing, we have given you a lot of information today, kind of in a nutshell, because we really want you to have an overall understanding of this law. These laws, really, because it's a bunch of laws that all interact. And to know that for all the controversy that sometimes surrounds it, that these laws really provide options. And so becoming familiar with these laws can help you understand how to work with the options that exist in the laws to meet the needs of victims, as well as to protect, as constitutionally and statutorily required, the rights of defendants. We really thank you for your attention and your interest in this. I see we really ended up with almost 500 people on the webinar. And now I'm going to hand things back to Mary to bookend our presentation and to try to cover some of the questions that came in prior to or during the webinar. Again, we thank you very much, and I would ask my fellow panelists, my sister panelists, to go on camera now so that we can work on some of the questions.
Thanks, Ellen. Yes, we did have some questions that came in. So I will go ahead and ask, and you can decide who is the most appropriate panelist to ask the question. We did have a question about what are the enumerated family offenses, but I think we did cover that. One question for Lisa came in. Did I understand Lisa correctly in that anyone on probation who is rearrested could be remanded with bail on the new charge?
So I think that's what we were just clarifying, that it has to be a felony offense, the new charge has to be a felony offense.
Okay, thank you.
And then it becomes a qualifying offense, not for remand purposes, but it's eligible for cash bail.
Thank you. Okay, another question came in. Does anyone have any suggestions about how to explain to victims that the appearance ticket is an arrest? This is difficult for them to grasp when the perpetrator is not arrested on the spot and the victim is still in danger.
I would say that it's hard to understand because honestly, I hadn't quite understood it in that way until we started putting this together. And Johanna said, no, an appearance ticket actually is an arrest under the law. And I was like, oh, I never really thought about it that way. And I think sometimes it's one of those things you have to educate victims about. And honestly, as we tried to point out at the outset, even if bail is set, there is no guarantee as to how long that person may be sort of out of commission. It could be very quick. I mean, bail could be minimal. It could be, you know, that they can run down to the ATM and get a couple $100 out and their bail's done and they're released. I mean, it's just important to understand that for victims, whether someone is given an appearance ticket or is in custodial arrest, there are no guarantees of any particular period of time that their safety may be enhanced. And that we always have to think about that when we're doing safety planning and really work quickly, because it could be a very small amount of time. And that's always been the case, even before bail reform, because you can't predict when's the person going to get an arraignment, when are they going to be fingerprinted, when are they going to post bail, and that can be a short time and it can be a little bit longer. But I think that's the best way to explain it, is that the function of these processes is not to assure the safety of a victim. It's really to make sure that the process can be done. And in the case, I think what Lisa's going to say, and I don't want to step on you, but where there's a chance of getting an order of protection, yes, that piece is about the safety of the victim. But generally, you know, as a general rule, it's very hard to predict how long.
Ellen, if I could just add also as a follow-up to that, I'm assuming that this is maybe from an advocate being the way that it was framed. I think it's also very important for those of you that work in conjunction with your local law enforcement to raise the issue that if it's an enumerated family offense, if it's something that's committed against a family or household member, an enumerated family offense, that the officer has the option and has the discretion to not issue an appearance ticket, even if it is an e-felony, even if it is a misdemeanor. Okay, they do have the option to bring the person into physical custody. And this is a new area of law. So I think there's a lot of people learning as we go and educating and working with your local law enforcement on the knowledge that in fact, on those lists of exceptions to the appearance tickets, that you do not have to issue an appearance ticket in those cases where those exceptions apply. Is something that could also help in your broader issue regarding, you know, potentially it sounds like there's a concern regarding issuance of appearance tickets and the safety. And then as Lisa had said, educating the law enforcement about that they can bring it in front of bring somebody in front in physical custody in front of the judge, and that then gives the option for the judge to be able to issue an order like Ellen talked about. So just making sure that hammering that part home.
I'm sorry. And I think also that when you're faced with speaking to a victim about this issue, you need to go, like, think about what's the practical issues that are facing the victim immediately, right? And so, of course, if you can't, like Johanna said, if the officer will not agree to do a custodial arrest, and remember, as Ellen was saying, you can send the person immediately to family court or to criminal court if the family court is closed. The family court can put all kinds of conditions on that order of protection. And remember that if the fear is firearms, that very important now, remember that those firearms with an ex parte order of protection, they can be ordered to be surrendered, and if the respondent refuses to surrender the firearms, family court judges now have the authority to issue an immediate search warrant for those firearms, so that if you are dealing with a firearm fear, right, you have a lot of tools now in the toolbox, and everybody is aware of this now, to at least address that, right, which could be an enormous fear in a case where you've had an appearance ticket issued. So remember, you have other tools now to make sure that concern is addressed.
Thank you. We have some other questions as well. How can victims have firearm surrender conditions effectuated?
So I guess I should address that. So, okay.
That's a whole other webinar, right,
Yeah,
Lisa?
we did a webinar on that. So, and it's really long. I guess I just want to say that if you have a firearm surrender directive on a criminal court order of protection or on a family court ex parte order of protection, law enforcement and the judges have been trained on exactly what has to go into that order of protection. They have to specify when it has to be surrendered by and exactly where it's to be surrendered. Law enforcement has been trained to go out, and if we're talking about the service in the family court, they know that they have to get those weapons surrendered that are part of that family court order directive. They are now have to report immediately back to the court as to whether they actually got any weapons from the respondent in the family court case. And if they did not, and they believe under the CPL requirements, the criminal procedure law requirements, that there are in fact weapons in the house, they can get an immediate search warrant issued to get those weapons, as long as it fulfills the requirements of the CPL. So there's a lot of ways for that to happen now, and the law enforcement and the judges have been trained on this. So, and I said we did do another webinar on it, but and I really think it's important for advocates to be aware of this, and where they think it's necessary. You know, you really want to aggressively pursue this information, because I know this is of major concern all over the state.
Thank you. Understanding that conditions and orders are different, how would officers know the conditions put forth by a judge? And if they did know, would the conditions being violated fall under contempt charge?
I'm going to answer on the if their conditions are part of an order of protection, then the order of protection registry and actual copies of the order of protection are available to all law enforcement, whether or not that. So if it's part of the order of protection, that's something that is a database that is available to law enforcement.
Thank you. Is non-monetary release the same as ROR? If you have non-monetary release conditions, is your release status considered ROR or non-monetary release, or both?
If so, ROR is release. So there's no cash bail involved in ROR. And with ROR, you can have conditions. So you can have ROR with no conditions, or you can have ROR with many conditions. And monetary bail, right, is cash bail and is not attached to ROR.
Thank you. Is there a place that keeps data on temporary orders of protection in New York court system?
Yes. As we've said, and so just to reiterate, and I know this is a big question statewide, and Johanna and Ellen and I have talked about this many times. So there's a New York State Order of Protection registry that is available to all law enforcement, which shows them all active orders. The judges have access to all orders of protection issued from the courts within our court system website, which is called UCMS. Law enforcement has access to order protection information through the federal, through some of the federal websites also that are not available to the courts, but are available to law enforcement. So the short answer is everybody, including town and village judges, by the way, I want to add that here, has access to information about active orders of protection. And some have access to information about all orders of protection that have ever existed.
And Lisa, if I can just clarify that last part about the federal system, that pertains to, so say there's an order of protection in another state, and they, come into New York State and commit a violation of that order of protection, then the NCIC, the officers have access to that. That's what I think you were referencing there. So just making sure people understand that.
Thank you. There were a couple questions in this same vein, so I'm going to ask one of them. How do the non-monetary release conditions work or are considered when bail is used in the context of flight risk? Many of the non-monetary release conditions, such as IPV interventions, do not address the flight risk, but the underlying safety risk. How is that navigated by judges? And I know, Ellen, I think you touched on that a little bit, but if anyone would like to address that.
Well, the IPV Intervention Program, again, this is it's not really about safety. It can be a condition that the court wants to see if the person will follow or thinks they need to follow while they're awaiting trial. That is not a long-term program. When that would be ordered, it would be a fairly short-term kind of thing. It might be, as I said, the same thing as far as substance abuse services, mental health services. The idea that maybe this person needs some services while they're awaiting trial. And I just think those are all pieces of things that can be ordered under the correct circumstances. But again, it all has to be considered by the court to be needed in order to assure the person's return to the next court appearance. And I know sometimes it does seem a little bit squishy, for want of a better word, but somehow the court has to, make these determinations and they have to explain why they made such determinations. And part of it is the person going to follow these things? Are they going to pay attention to those orders of the court? I think that's one of the things that courts can consider. If they don't follow those, maybe those conditions need to be changed.
And I think also the idea is that perhaps when you're trying to assure that the defendant is going to return to court on the next date and you're trying to make that determination, so you might say, well, based on the background and all of the other things that we talked about earlier today, I think that ROR, straight release on your own recognizance, might not assure that. But I feel much more confident that ROR plus some drug treatment, plus some counseling, plus my knowing that this person is enrolled in school, et cetera, those are the least restrictive alternatives that, as combined with each other, I believe we can use to assure the defendant's return.
Thank you. Can you define eligible, reliable electronic monitoring program?
Lisa, do you want to take that?
Well, my understanding with electronic monitoring is that a lot of these programs are actually are previously vetted by the court system to ensure that they can be used. So I don't know exactly what each district is using to vet that, but I know that, you know, obviously they have to go through a process. So for instance, I know that in a lot of jurisdictions, probation is actually working on electronic monitoring. So that's an example of, you know, obviously an agency that is used for that system. But the courts, the counties have to vet these agencies to make sure that they have a track record of being able to do electronic monitoring, which is one of the things that I think has made this piece of the legislation sort of complex.
Yeah, and another piece of it was that the original legislation, and it still does, requires that it cannot be a private for-profit entity that does the electronic monitoring. And in a lot of counties, that's exactly, if they had it, that was how it was being done. And so that's been a bit of a lift. And so it has to be done by either an arm of the government or a not-for-profit that is contracted through the government. It cannot be a private entity that's for-profit who is doing that. So there's just some pieces that have had to be worked out, and that I think if your county has one that they're using, it probably means at this point that it is eligible. I added the word reliable because, you know, sometimes electronic monitoring may just not be realistic in maybe the geography of your county. It may not, you know, when you get a notification that someone has gone outside of the area they're supposed to be outside of, it maybe takes so long for that to happen. So it's just important to understand how those things work in as much detail as you can.
Thank you. Who monitors the person when a judge RORs a defendant with special conditions? What if the defendant fails to comply?
So that brings up a really important question about information sharing. Now, depending on what the special conditions are, the judge so the defendant's going to have a return to court, you know, at some point, a new court date. If it's an agency where the judge has told, you know, the defendant at arraignment, you're going to report to the following agencies, you're going to do these conditions are a part of my ROR, the agency is going to report back to the court. Some of them, though, are the kinds of conditions where the victim the victim may hear from the defendant's family, which is very common, or defendant's friend, that the defendant is not complying. So one of the things that's really important here, and I know how difficult this can be, but it's very important for victims, survivors, their families, and advocates to be able to be in communication with the district attorney's offices and law enforcement to make sure that if there are violations of ROR conditions, and they're not the kinds of violations that a court may be getting immediate information about, that you get that information to the district attorney or to law enforcement so that it can get to the court, because the court obviously doesn't do its own investigations, and apart from agency communication and transmission, won't have the information. So, you know, don't be deterred, get it out there.
Thanks, Lisa. So we're right about at time. We did have some questions that came in that we didn't have time for, but as we said, we can take a look and provide a Q&A document later when we are able to answer those questions. And I just want to reiterate, because a few people have asked, yes, everyone will be receiving the PowerPoint for this webinar. Everyone who was registered will be receiving that. And also you will be receiving an evaluation. And again, please do fill that out, because obviously this is a topic with a lot of interest and questions. And so we want to make sure this was useful and what else might be useful in this regard. Thank you so much for joining us today. And thank you so much to our presenters for the wonderful information on this very complicated topic. We will be in touch with the follow-up information, and I hope you all have a great day.